It's a novel. Yeah, we're used.
Time for this special meeting of the Yuma City Council, 5 p.m. on Monday, May 14, 2012, has arrived. I will call the meeting to order and ask the clerk to call the roll.
Councilmember Stewart.
Present.
Councilmember Thomas.
Present.
Councilmember Deason.
Present.
Councilmember McClendon. Present. Councilmember Brooks. Present. Deputy Mayor Johnson.
Present.
Mayor Krieger.
The purpose of this meeting tonight, as set forth on the agenda, the City Council investigation authorized pursuant to Article 7, Section 10 of the Yuma City Charter of allegations made as to the actions of Mayor Alan L. Krieger and the conduct of the office of the mayor. I would ask that the special counsel please come forward and present his report.
Yes, Deputy Mayor and Council, my name is David Kennard, I'm with the law firm of Gus Rosenfeld in Phoenix. Our firm was retained as special counsel to the City Council and to conduct the investigation that the Council authorized with its vote on February 1, 2012.
Excuse me, Mr. Bernard, I'm the mayor here, and I'm going to excuse myself from the dais and sit in the audience. Sorry for the interruption.
Thank you. As a result of the assignment that we received, and drawing on my experience in conducting many similar investigations over the years, I proceeded to...
Excuse me, sir. Some people are indicating that they can't hear you. Could you pull the mic in a little bit closer?
I will, and I've got a little allergy going. I'll try to speak up a little bit and bear with my voice just a little bit. Thank you. I appreciate it. If I start speaking too softly, please remind me. So as a result of the investigation that we were asked to conduct, I interviewed witnesses. I ascertained those who might have pertinent information from a variety of sources. I have seen the allegations and charges, not only that were brought forward on January 4, but elsewhere throughout the spring. Have looked at a variety of documents. In fact, there is a binder of documents that I found to be pertinent to the investigation that is available in the clerk's office, or will be, I didn't with the clerk right answer tonight, and they've been available electronically to Mayor Krieger's counsel and to the city administrator. We looked at those documents, we reviewed property records, we reviewed business records, a variety of information that had a bearing on the issues involved in the investigation. And part of the investigation was to determine what are the issues, because what you usually get in a situation like this is people hit kind of the tip of the iceberg in explaining this is what my concern is, and it may only articulate a little part of what the real issue is as to whether there is conduct there that should or should not have taken place. I'm bringing forward tonight the report that has been shared with the mayor and council today, hard copies provided tonight, that contains, I believe, a fair analysis of evidence. That's one thing that this council talked about over the spring was we need evidence, not just allegations. What is the evidence? I've done my best to ascertain what the evidence is and what I believe a fair reading of the evidence shows as it relates to the applicable restrictions and regulations of statute and the charter and general principles of legislative conduct and authority that a body like the city council has. You're probably going to have to sit once in a while here. It is a dry heat. One of the things I would like to address up front, because it comes up in every one of these investigations, is the issue of politics, and whether politics was involved in the investigation, drove the investigation, determined the outcome of the investigation. When I take on an assignment like this, I take it on independently of those considerations. I do not live, work, or vote in Yuma. I do not do business here other than as I'm needed on issues like this. This isn't, I don't have an interest in how political fallout falls from the making and defending of charges like this. There are always politics, if you will, that surround every single one of these investigations. Frankly, it's inescapable because you are, after all, elected officials, which is a political process. I've represented cities and towns across the state of Arizona for 32 years. I represent political clients. That's the nature of the beast. Doesn't mean that my work has to be political or that it is politically ordained what an outcome would be. It is not. If I felt that was the case, I would not be living up to my responsibility not only to the council that hired me, but to the citizens of Yuma that you serve. So I will tell you, and I suppose maybe from my report or my presentation you might see evidence of it, but I will tell you very sincerely here tonight that this represents my best estimation of where the real facts lie and not where the political considerations would take form. This investigation also has been conducted by me with a very, very high degree of independence from you folks and from city administration. We had one executive session which I gave this council legal advice. It was an executive session for that purpose. That's what was conducted. This council, and I thank you for it, has allowed me to operate independently without what many clients, public or private, find it hard to do, which is to let go and not have their fingers in things. You've done that. City administration has done that. Frankly, I have done my best to keep Mr. Wilkinson and Mr. Moore in the dark about what I was doing, what evidence I was developing. I had no contact with Mr. Moore with regard to this investigation, and your city administrator has provided me logistical support as I asked him to arrange for times that I could speak to you folks and others, and for other logistical support. And I appreciate that assistance. It made the process run a little more smoothly, and save you folks some dollars from me not having to chase some of that information down. I want to touch for a minute on an issue which the mayor, through his attorney, has raised with me. That is whether this council has any authority to conduct this investigation. You do. That authority comes from several sources. I spend quite a bit of ink explaining this in the report because I think it's foundational to the entire investigation itself. This is a legislative body. You're not just a group of people who meet here on a committee because you think you'd like to do good for the citizens. You have legislative authority delegated to you through your charter from the state of Arizona. This body is as much a legislative body as the state legislature is or as Congress is. Dating back several centuries, parliamentary or legislative bodies have had inherent authority recognized by law to conduct investigations into the conduct of its members. At some levels, that includes expelling a member from their body if they find the conduct to be incompatible with the office. This council does not have the authority to expel the mayor or any member of the council. But you do have the authority to investigate conduct and to determine whether the conduct is appropriate or inappropriate for the standards that you would set for service to the public. That's something that has been recognized for centuries in the law and is recognized, frankly, even in Robert's Rules, which this council has adopted as its rules of procedure. More fundamentally as well, your charter serves as the organic document for the city of Yuma. It serves as your constitution to some extent, although it serves in that way in addition to the state and federal constitution. But within your charter, on matters of municipal concern, your charter governs. And your charter says that you have the authority to investigate and the authority to use the word punish. I would use the word discipline, correct? What it calls disorderly conduct of your members. Well, if you go back and look at the references I provided, disorderly conduct means conduct that is unbecoming to the body, that is disruptive of your proceedings or of your reputation and this government's reputation in the community. So you have the authority to do that under the charter as well. I won't spend more time on that. It's part of the legislative standing of the council under your charter and under the law. The manner in which these allegations were investigated were prioritized by me in conducting the investigation, as I feel I have the reasonable opportunity to do on your behalf. I'm not saying that any of the allegations are trivial. They're not. But we have allegations that the law has been violated. Conflict of interest law, open meeting law. We have allegations that the charter has been violated. We have allegations, I guess, that the mayor's demeanor in dealing with other people in some ways is quite harmful and even threatening, but in other ways is perhaps too rough and abusive. I think the mayor himself put it as coming from rough German stock, tough German stock. Those sorts of allegations are not trivial. I've worked inside government. I know what it means to have the organization function well and what it means to the community. However, for purposes of my investigation, frankly, those types of allegations, particularly as they relate to personal relationships generally, were of less of a focus of mine during the investigation than the charges of violations of statute. I also had lots of suggestions as to people who might have information for me that might be beneficial to the investigation. for the first time doing this, I called a newspaper reporter as well and asked if he had any information for me, but of course he couldn't reveal anything he might have had because of protecting his sources. But it was kind of fun to make the call. But I called lots of people, I talked to lots of people, I interviewed people. There were people that ended up not having direct knowledge as it was thought they might. And so obviously I don't rely upon what they had to say to me. There also were interviews I did not conduct. I know a process like this is harmful to the council and to the community the longer it goes on. If I interviewed everybody I could have interviewed, I'd still be at it another 2 months. That's not warranted and it's not healthy for this community. It's also, some of the interviews I could have conducted would have been of members of city staff who are frankly in a no-win situation like this, if you don't mind me talking bluntly to you, having been there. Whether they say something or they don't, no matter what they say, there's absolutely a no-win situation for many members of city staff to get dragged into this. They didn't run for office, they didn't ask for this kind of scrutiny. Therefore, I did not conduct those interviews. I did not feel, in my judgment, second guess my judgment if you like, but in my judgment, I did not feel that the prospects of getting information that was reliable and thorough in conducting those interviews was worth the cost, was worth the human cost, was worth the organizational cost. I know this is difficult, folks. I know it's been painful. I was trying my best not to be Sherman marching to the sea, leaving nothing but scorched earth behind me. So I did not conduct some of those interviews. And again, that reflects in part prioritization of mine, that some of those matters were of less significance in terms of the findings of an investigation like this than others would be. So I wanted to report that to you up front. Other than that, I did conduct interviews of all of you, conducted interviews of appointed officials and former officials of yours, and some members of the public who were told to me might have direct information on some subjects. And I've tried to relate that in the report, and I'll cover some of that tonight as well. I would like to spend just a moment discussing the fact that a lot of what we're going to deal with tonight has to do with conflicts of interest. Some with open meetings law as well, but mostly some of the big issues here are conflicts of interest issues. Conflicts of interest issues are something that if you've never served inside government before may be difficult to grasp when you get into a position like this. The League of Arizona Cities and Towns conducts training for newly elected officials. When Mayor Krieger was Councilman Krieger, he took advantage of that opportunity and went to league training on that. That's documented in the report, and there are backup documents in this document binder that show that. The League of Cities and Towns also offers refresher training, or I think they call it hot button issue training at their annual conferences for any elected official in the state who would like to take advantage of that. And Mayor Krieger attended a couple of those conferences. I had no way of recording whether he went to those sessions, but they were available if he felt they were needed. The League provides guidance on these things. So does the city attorney. I have a packet of information that the city attorney uses with new council members as you come in, where it goes over the conflicts of interest, open meeting law, public purpose law, things of that nature, and provides actually copies of the statutes to you and goes over it. So that information is available and helps to inform the public official whose duty it is to keep apprised of the business relationships, property ownership relationships that he and his relatives that are covered by the statutes have at any moment in time. that could cause a conflict of interest should some particular item of business come before the council. That elected official is the only one in the best position to make that judgment and can always ask for even a formal written opinion from the city attorney, which should then be put on file in the office of the city clerk and open for public inspection, but which could be officially relied upon by the public official if it determined no conflict existed. Without that, these public officials making their own judgment and living up to the conflict of interest laws day in, day out, and meeting after meeting. That's the way that local government and even state government works. The conflict of interest requirement, or the trigger for the main conflict of interest statute, there's actually several of them. But the main conflict of interest statute has to do with matters of public business that come before an official. Elected officials serving in a body like this, appointed officials, everyday employees, rank and file employees, are subject to this statute. If that public official has a pecuniary or proprietary interest that may be affected by a matter of business that will come before the body, that's what triggers the conflict, and I'll talk about what follows after that. Pecuniary means monetary, money, financial interest in some way that would be affected. Business interest, an investment interest, a gain or a loss, some financial interest that could be impacted depending upon how the decision of the body goes. The other proprietary interest is property, but real property, personal property, intangible property, anything that the law considers to be a property right or interest. Most often you see those where perhaps planning and zoning commissioner's property is close enough to a property that has a rezoning application on it that it may be affected by the rezoning action in some way. That could present a conflict of interest. So we'll talk a little bit about that tonight too, because there are some properties that Mayor Krieger owns or owned or his family owned that are at issue in some of the allegations. A property or monetary interest, in order to be significant enough to trigger a conflict of interest by a public official, must not be trivial, it must be substantial. It must not be speculative or remote, meaning it may never occur, perhaps just as likely as not to ever have any impact. Then that becomes speculative enough that the courts are not going to require the public official to declare a conflict today and not deal with an issue in their official capacity. However, and I've included references and some quotations from Attorney General opinions in this regard, because the Attorney General's office is the main enforcement agent for open meetings law and conflicts in the state. There's a very broad view of this. The effect can be direct or it can be indirect. It doesn't have to be direct. It doesn't have to happen today, and it doesn't have to be certain. The interest being served here is that the public is getting a decision that's based only on what's best for the public in that public official's view, and not something that is impacted by self-dealing by the official. By being so broadly, by casting such a broad net and requiring people to disqualify themselves where there isn't any actual evidence of corruption or self-dealing, the statute prevents the very types of corruption that we hear about and abhor from other places in our country and elsewhere. So, it's meant to be that broad. In applying it in this investigation, that's the spirit in which I have applied it, subject to the requirements that a proprietary or property interest be present and not be speculative or remote. If a public official has a conflict of interest, it's not enough simply to refrain from casting a vote. This is very fundamental. The public official cannot participate, according to statute, in any manner in the government's consideration of that item of business. In any manner means out here on the dais, at home on the phone, in a workshop where no vote's taken, informal get-together over coffee, it doesn't matter. In any manner, that public official cannot deal with that issue as a public official or with other public officials with whom they serve. Again, so that those others making decisions are not tainted by the self-interest of the person with the conflict. It's, again, remedial. It prevents, it's preventative. It prevents the insider preference situation from occurring in the first place. So it's not enough to engage in conversation in a work study or a regular session only to decline and refrain from voting. Your own charter says one of the reasons you refrain from voting is if something deals with your own conduct, as this investigation does the mayor. Also, if you have a conflict of interest. So that's something that you're required to declare. You're required to declare the conflict. You're supposed to declare what it is and put that on file in the city clerk's office in a file that she keeps available to public inspection. It's not you're disclosing it to your fellow council members, which of course you are. It's you're disclosing it to the public. It's open to public scrutiny. It's open to public inspection for the same reasons we have meetings in public. So that when the decisions are made, the public knows the information that went into those decisions. It serves the same interest, the public disclosure part of it. And then you have to refrain from having any involvement or participation in it, including not voting on the item. I'll come back to that in a few minutes because in some of the conflict of interest allegations, the mayor did in fact refrain from voting. But we're going to examine whether that went far enough, if an actual conflict of interest existed. A conflict of interest is a factually driven analysis. It's not the same from any two scenarios, one to another. It depends highly upon the facts and circumstances that are involved in a particular instance. And those have to be examined against not only the requirements, the legal requirements and reading of the statute, but also the public purpose behind the statute. In effect, it's transparency in government before that became a popular term. It has to do also with conflicts that a close relative has. The statute defines what that is, but certainly your spouse, your children, your immediate family count. That's the easy one. Goes out to not very much further than that in terms of degree of kinship, but the statute's very specific about that. You don't normally have to go out there and explore the edges of that, and as none of that is at issue here as to whether the person potentially with the conflict was related enough to the mayor and county. That's not an issue. So that in effect, 5 prongs of the conflict of interest analysis, when you get right down through it, you factor in all the case law, the attorney general opinions and everything. First of all, it's the person, a public official to which the conflict of interest law applies. There's a lot of litigation on that in some areas dealing with some bodies that are not traditional governments in nature. City councils clearly are, no question. Does a public official have a pecuniary or proprietary interest involved? Is there financial or property interest that is involved or may be impacted by the decision? Is that interest so remote or so speculative that it should be disregarded for conflicts of interest analysis? And that's the use case. Fourthly, there is a set of interests that the legislature has exempted from conflict of interest analysis under the statute, which the legislature calls remote interests. It's different than this court case calling something speculative and remote. A remote interest under the statute means, do I fit within one of these several statutory definitions? Do I own stock in a corporation, publicly traded corporation that's less than a given percentage of the stock and less than a given percentage of my income, things like that. If I do, it just doesn't count. It's exempted. None of the interests that are at issue here in this case involving the mayor come within those statutory exemptions. And the way that the conflict of interest statute is written, if it doesn't come within the exemption, it automatically is a substantial interest that will trigger a conflict if there's an impact on it that's direct or indirect. And then again, what I just mentioned, the last inquiry would be, okay, fine, you've got this interest, it's not exempt and it's not too remote and it's proprietary pecuniary. Is there something about the conduct of the public's business that may have a direct or indirect impact on it, such that you have a conflict of interest? And the impact may be positive or negative. It doesn't mean you always lose money. If you make money by the way the vote goes, that's a conflict of interest as well, because it taints your decision making. So either way, it would be a conflict of interest. With regard to the open meeting law, I want to talk generally about that for a minute. As it relates to this investigation, the open meeting law requires the decisions on public business to be conducted in public meetings. The exemptions for executive sessions are stated by the statute, and for purpose of what we're talking about here, primarily deal with employment matters of those employees that you would deal directly with, legal advice, directing litigation, property negotiations, things of that nature. What comes with the executive session, though, is statutory confidentiality. What happens in the executive session stays confidential by law. Some of it's covered by other privileges anyway, like the attorney-client privilege, but under the confidentiality of the executive session statute, both the minutes and the discussions and any confidential documents reviewed must remain confidential. Your clerk is a tiger on this issue. I can understand from having met with him. She keeps the minutes under lock and key under her own thumb. And nobody gets to take them, and if you want to see them, you've got to have her dispensation to do so. And I wish all my city clerks were that great about that, but she really is towing the line on that. And we'll talk about access to executive session minutes in a few minutes on one issue. But the confidentiality, breaching the confidentiality is every bit a violation of the open meeting law, as if you held an executive session for an invalid purpose or you conducted some matter of the public's business outside of the public meeting. They're all violations of the open meetings law if they occur. All right, I'd like to talk about the specific allegations relating to conflicts of interest. This is honestly where much of the meat of the investigation is, and where a lot of the facts are and have to be examined, and where some of the key, I think, legal issues are in the case. As you know, on January 4th, Mayor Young came forward and made statements from the floor, and part of what she claimed was conflicts of interest that Mayor Krieger had not disqualified himself on. I've looked at the conflicts of interest issues that I see as a result of facts that the investigation has considered, and breaking down into several discrete areas that are set forth separately in the memorandum starting on page 13. First of all, I want to talk about the one that I think should be the most obvious. Since January 4th, and the vote on January 4th to put an agenda item on the agenda to consider initiating this investigation to look into the charges that former Mayor Young leveled, there has been a potential action by this council that affects the office, or affects the standing in office of Mayor Krieger. Does Mayor Krieger have a proprietary interest in being, does he have a property right to be mayor? No. These are public positions, folks. None of you own your position. None of you have a property ownership right in a public position. That's been very well established in Arizona law. However, there's a dichotomy in Arizona law, too, that recognizes the difference between some people in public positions serving without pay and those who are paid positions. Those who have paid public positions have a financial interest in the position. I know you don't get paid very much. And dealing with things the way you do, you don't get paid nearly enough probably. I probably upset the taxpayers by saying that. But nevertheless, you have a financial interest in your position. The mayor has a financial interest in his. His salary is $12,000 a year. It's a financial interest. This council doesn't have the authority, regardless of what this investigation shows, to directly take that away from the mayor. I grant you that. You don't have the right to fire him. You don't have the right to expel him from the body. You don't have the right to suspend his pay. But again, the impact on a financial interest can be direct or indirect. You don't have to have a direct impact. It doesn't mean if I've got a conflict and if something comes out a certain way, as a public official, I have to write somebody a check. Conflicts of interest go much further than those kind of simplistic situations. As you could tell from how a lot of this has unfolded this spring, there's quite a lot of interest by the mayor and how this affects his position, his supporters, and others as to how it affects his position. Again, I try to stay out of the politics, but I do notice that there's a lot of interest in it. Has no bearing on my investigation. He's got a financial interest at stake that may be impacted by investigation anyway. The main argument against it is a case involving a sheriff in another part of the state whose sister was charged with a DUI. He barely touched the investigation. She might someday be fined if she was charged with a DUI. I think my recollection is she ended up not being charged with a DUI, but he didn't make the decision whether she got charged or not. The voters might not like the fact his sister had a DUI a couple of years later if he ran for re-election, but it wasn't his DUI. It didn't affect his status as a peace officer. He wasn't going to lose his certification from AZ Post. Again, these are factually based considerations and decisions. This is not that case. This is a case about the mayor's conduct of his position. That case was about the sister's DUI. So that case does impose the requirement that the financial interest not be so remote or so speculative as to be inconsequential and should be disregarded. In my judgment, that doesn't come into play here at all. The mayor's lawyer respectfully disagrees with me on that. So we've agreed to disagree on that. I believe that all of the votes that have occurred on January 18th, January 25th, February 1, and the vote that will occur tonight, if the council takes action of some kind, all involve action by the council that has an effect upon the mayor's interest in his position. Therefore, I think Mayor Krieger has and had a conflict of interest every single time. As I mentioned before, it's not enough that the public official refrained from voting, and Mayor Krieger did refrain from voting on, I think, January 25 motion for reconsideration and then February 1st motion to actually authorize the investigation to go forward. But if you recall January 18th, the mayor participated very directly and significantly in that discussion, not only as a member of the body, but as the chair of the meeting. There's a lot of power in the prerogative of the chair, folks. And so how that's exercised in a way, in a proceeding that affects your personal conduct, it almost would be impossible to do it in a way that wasn't tainted, I would think. But it certainly has enough of the direct or indirect impact on the position that it calls into question whether that was done free of any other influence that the public is entitled to expect, to receive. The mayor argued against it. The mayor voted against it. There was a 3-3 tie vote on the motion to initiate the investigation 2 weeks after Mayor Young's comments when the investigation came here on the agenda. It was a 3-3 tie. Somebody cast the deciding fourth vote. It was Mayor Krieger, and it was a vote to kill the investigation before it got started. That's a conflict of interest, folks. You don't get to do that. If Mayor Krieger, this is a matter of parliamentary law, if Mayor Krieger had not cast a vote, if he had stepped down and not declared a conflict and not participated, and there had been a 3-3 vote, by this body, that would have been non-action on the motion to initiate the investigation. Non-action means you can bring that back before the body without all the special hoops you have to jump through to reconsider a final vote on a matter. If you recall, following the vote on January 18th, there was a meeting on January 25th about reconsidering it, and there was a lot of hoopla about what it takes to reconsider, and whether the reconsideration had to have occurred only on the 18th, of the night when the vote was taken. That was one of the issues. Was the reconsideration too late? Was it a standing body? Was it not a standing body? How does the reconsideration restriction apply? Who voted on the prevailing side? They're the only ones who could call for the motion to reconsider. None of that is applicable on a 3-3 tie vote. It was non-action. It was the fourth deciding vote that triggered all of that. That's a conflict of interest. And it had an effect on how the public's business was done. It's also a conflict of interest to go around behind the scenes and try to get people to vote your way on something that comes before the council that affects your interests. There's evidence this mayor did that, or attempted to do that with council members. That's a conflict of interest. As I'll discuss in a minute, it's also an open meeting law violation in my view. The public's entitled to have your deliberation and vote in a public meeting, not somewhere else where your decision has been made because somebody forced it. So on all of these votes having to do with the investigation and the mayor even discussing and criticizing and trying to cajole the council into not doing this and then stepping down, it's not enough under conflict of interest laws. The conflict still occurred. The violation still occurred. And the report discusses some specifics and how some of the behind-the-scenes maneuverings were done. I don't think we have to recount all those here. It's in the report. I stand by every bit of it. The witnesses explained this to me and how this was done. Some of them involved using personal information that none of you would have the right to have on another member of this body in a way that would discourage that person perhaps from opposing the mayor's position at the hearing, at the meeting. And since that council member was a federal employee, there could have been a violation of federal law there by somebody getting the information. But the point isn't where the information came from. The point was how it was used. If you know something about me, or you know what I want, and you give me what I want, if I vote your way, that's not honest government. That's what conflict of interest is meant to avoid. Another conflict of interest has to do with the Eckerd construction issue. Mayor Krieger owned and operated his own construction company for about 14 years, specializing in the erection of pre-engineered steel buildings, holding an A11/commercial license from the Registrar of Contractors. Culminating on April 15, 2011, a deal was struck and closed, the sale closed, where Mayor Krieger and his wife, they were co-owners and officers in the business, sold the assets and business operations and contracts yet to be performed to Eckerd Construction, April 15th, 2011. Okay. Obviously, it was in the works a little before that. I didn't get into exactly what date with the mayor because I'm going to focus on that on a one-year period primarily. It started on April 15, 2011. Under the terms of the sale, there was a dollar amount paid for the assets and business of Krieger Construction Services. I did not ask what that lump sum amount is. That prize into personal business that I don't need to know. But what is important is that there was a lump sum paid down in April of 2011, and then the balance of the purchase price was to be paid in monthly installments over the next 15 years, I believe. That puts the mayor in a financial relationship with Eckerd Construction for 15 years. For the first year after the sale, there was more of a financial involvement between the mayor and Eckerd Construction because there was a non-compete agreement. The mayor could not go out and start another construction company to compete with Eckerd for a year. That started on April 15th of 2011 and went through that same day in 2012. During that period of time, the mayor also agreed to essentially be employed, whether you call it consulting or employment, whatever. It was a compensated position. He was on the payroll so that withholdings would be taken out, and Social Security and things of that nature. He was being compensated for his efforts for Eckerd to, in essence, run the steel construction division of Eckerd Construction, especially for the two jobs that were already under contract with existing customers of Krieger Construction. So the employees, for the most part, moved over to the new division at Eckerd, and the mayor felt a responsibility and undertook a business responsibility to oversee those contracts, to actually make sure they ran, they started on time, the jobs got done right, and so forth, to oversee those jobs for Eckerd during the next year that ended just a month ago. So he did that, and there was extra compensation paid on a monthly basis for that, which ended on April 15th of this year. During that period as well, the mayor served, let me back up a minute, for state registrar contractor purposes, the registrar of contractors requires every contractor's license to be tied to someone who is the qualifying party, which means they're the person who will meet the qualifications that the registrar sets and the law sets to hold the contractor's license. They have the required number of years of experience and knowledge in that trade or in that business and pass exams and everything else that the registrar of contractors requires. They look at the person's background. They're not dishonest. They're not somebody who can't hold a state license for reasons like that. And they get authorized to be the qualifying party on the license. The corporation itself can't be the qualifying party. It has to be a person. Well, for Eckerd Construction, and I used to represent small contracting companies, when they're sold, it's not uncommon that the buyer doesn't immediately have the experience or be already set up in a position to assume the qualifying party position on the license. That was true with Eckerd. So the mayor continued to be the qualifying party, agreed to be for the next year during that one-year non-compete period, in which he was consulting with Eckerd on the license. And in fact, the registrar of contractors website shows, and those materials are in the documents as well, that Krieger Construction's A11, which is steel building license, commercial license, is inactive. And that Mayor Krieger is the qualifying party for Eckerd's A11 steel building / commercial license. Now, Eckerd Construction has other building contractor licenses, commercial and residential, for which the mayor is not the qualifying party, but is shown as an employee of the business. but he is the qualifying party for Eckerd. In essence, the business partner, if you will, without his status as a qualifying party, and I confirmed this in our interview we had last week, Eckerd would have had to shut the business down that he had just bought until he became a qualifying party. He couldn't keep it going as a going concern without the mayor stepping over and becoming a qualifying party for Eckerd on the A11 license. Not uncommon at all. Okay. Apparently Eckerd hasn't done his homework to get himself up to speed by April 15th of this year, because he's still not shown as a qualifying party. The mayor's still shown as a qualifying party. And I asked the mayor about that. He wasn't aware of it. He was going to check into it. It isn't a matter of major significance to me. The significance is that during that year, he was more than just somebody being paid an annual amount or a monthly amount off of a purchase price of a business. He wasn't just a former owner or investor who was being paid off. He was actively involved with Eckerd's business and was required to be. The qualifying party is the one who's on the line to the registrar of contractors for workmanship, honesty, and everything else, and how that work is done. All right, why did I go into all this detail about it? Oh, excuse me, there's another substantial news. Jacob Eckerd, the mayor's son, is now an employee at Eckerd Construction as well. An employment of a relative by a business, and we think about a bid coming in here, and if your son or daughter or spouse was an employee of the contractor who was giving a bid on a city project, you'd have to recuse yourself because you'd have a conflict of interest, that sort of thing. Nothing wrong with it, it's just a conflict. So, what occurred? What came before this council during that 1 year period? Let's just focus on that 1 year period. What came before this council during that 1 year period that presented a conflict of interest with regard to Eckerd Construction? Local preference. The local preference ordinance. It came before this council last fall and was discussed. The mayor did not declare a conflict of interest. It came before this council for a vote, I believe it was on February 1. At which time the council passed a version of the conflict of interest ordinance, not conflict of interest, local bidder preference ordinance, that gave the preference only to businesses within the corporate limits of the city of Yuma. So a local Yuma business who got the local bidder preference had to be within the city limits. And the matter that was hotly under discussion at the time was, should it be extended to businesses in county islands as well who aren't in the incorporated limits of the city? Last fall, Mr. Eckerd spoke on it. This spring, Mr. Eckerd spoke on it at some length. Why? Because Eckerd Construction is located in a county island. In fact, I don't know if it was Deputy Mayor Johnson or someone else who offered a pre-annexation agreement to Mr. Eckerd during the conversation. Would he be willing to sign a pre-annexation agreement to get the local preference to come into the city? And I've watched the tapes of all these meetings, and Mr. Eckerd said, well, no, thank you. But the point is, the council had a policy call to make in conducting the public's business. And just Mr. Eckerd's own involvement and discussion over 2 meetings about what a difference this makes to a local business to have that preference, and how you'd be favoring the businesses within the city limits and getting the city's business over those who happen to be just across the line, shows its importance from a financial standpoint. I think Mr. Eckerd even mentioned how the percentage by which companies usually win bids and so forth, the local preference can make quite a difference on that. Well, who cast the negative vote on the motion to pass the ordinance that limited local bidding preference to contractors within the city limits, contrary to Mr. Eckerd's request? Mayor Krieger. He chaired the meeting, he engaged in the conversation, and he voted on the motion. at a time during the 1-year period that he was not only had sold his business to Eckert and his son was employed there, but he was actively a qualifying party on the license and was running jobs for Eckert to make sure they ran right and getting paid extra compensation as a consultant/employee during that period of time. That's a conflict of interest that should have been declared, and the mayor should have had nothing to do with the discussion on either one of those days. And I see that was on February 1, ordinance number 2011-39. All right, open meeting law. Again, one issue, and I'm not going to go over this in a lot of detail, we already covered it, is when you start trying to line up votes, no matter how you do it, you're my golfing buddy, I'll pay for you around the golf, whatever. When you start trying to line up votes outside the public meeting and secure hard commitments or how somebody's going to vote, when you're supposed to be looking at the policy considerations in this chamber and making your decision here when the public can see. When someone starts to use their official position to garner those votes in advance and predetermine the outcome of the vote in the dais, in the chamber, that is an open meeting law violation. It would clearly be an open meeting law violation if it added up to 4, because the majority council of pass items 4. I suggest to you 2 things. First of all, given the nature of the conduct here and how directly it was targeted on securing, absolutely securing votes against an item of city business that would harm the mayor's personal interest, and the fact that it was done in a way that was, I'll use the word abusive. I think you are entitled to consider that both a likely open meeting law violation, even though it didn't add up to 4, and consider whether that is conduct that is of the nature that represents this council to the community in terms of your legislative review of the office of the mayor. The other open meeting law issue has to do with confidentiality. Again, as I mentioned a few minutes ago, it is as much a violation of the open meeting law to breach executive session confidentiality as it is to invalidly hold a meeting. The Chamber of Commerce Executive Director, Mr. Rosevere, spoke to me. I approached him. He spoke to me about an occurrence late last year. It was just in the putting together of one of the, what's it called, Good Morning Yuma Chamber breakfasts, I think they're called. And the mayor approached him and was talking to him about what had occurred in the executive session. Discussions that were held in executive session about employment matters. And that there was something the mayor was trying to get done. I don't need to recount the details here. It happened in executive session. I shouldn't recount the details here, but that the mayor was trying to get done and couldn't get done because there was an obstacle that had occurred in the executive session. The mayor also had, and the way Mr. Rosevere put it, was waving around and pointing at what he understood to be a confidential draft of a proposed employment agreement to be voted on for the next term for the city administrator. Mr. Rosevere recounts saying, I don't want to see this, I don't want to hear this, I can't hear this is illegal, I can't hear this. The mayor cannot recall any discussion of that type occurring. However, when I asked him if there's anything he might have shown to Mr. Rosevere that would have been a confidential document out of executive session, his response was, well, It could have been the city administrator's contract, but that's a public record. Frankly, folks, I found that to be a little bit inconsistent with the idea of having no recollection of the conversation. I don't know if the contract was a confidential contract or not. Mr. Rosebeer understood that's what was being shown to him and didn't recall the mayor ever saying anything about this being a public document. What he recalled was that the conversation was the mayor wanting to share with him an event, if you will, about some things that occurred in executive session. The mayor doesn't think that occurred that way. He doesn't recall the conversation. This is one of those things where you have to put yourself in the shoes a little bit as if you were on a jury and say, which version seems more credible to me? I'm not infallible, folks, but I've been at this a long time. I've been a trial lawyer for 32 years. I've been a municipal lawyer for 32 years. I've conducted any number of these investigations and administrative hearings. I'm an administrative hearing officer for the Supreme Court of Arizona. Not to toot my own horn, my point is, I'm not bad, I think, at making those kind of judgment calls, but they're my judgment calls that you see in the document as to where I think the best credibility of the different stories lies. In this case, it's with Mr. Rosebeer. He knew details. He knew the date in which the conversation occurred, where it was, what he was doing, where he walked to get away from the mayor, and where the mayor followed him to keep showing him the contract. He knew it was the city administrator's contract that the mayor later confirmed. I don't see how Mr. Rosebeer would have made this up and had those details in that way. Mayor Krieger shared, I asked him, was there any reason why, Mr. Rosebeer's account might be biased? And, one of the things I try to take into consideration, and the only place I take into consideration the politics of an investigation like this is where it gives witnesses potential bias, because you have to take that into account no matter what the bias might be. The mayor recounted he thought that Mr. Rosebeer might have different political affiliations than to the mayor, and so I take that into consideration, but in looking at the facts of this one, folks, I think I find the details provided by Mr. Rosebeer and the confirmation that it was the administrator's contract, confidential or not, that was shown to him to carry the day in terms of which version is more credible. That being said, that means that what he was told that came out of the executive session should not have been told. I think that's a likely violation of the open meeting clause. The other issue of potential open meeting law confidentiality that came up is what launched me into the issue of the confidentiality of the executive session minutes and how tightly held they are. I was told by your former clerk, by your present clerk, by your deputy clerk, and by the mayor how closely held executive session minutes are. Copies are not circulated around. They're not left, they're not provided to the mayor and council as a matter of course. If you want to look at them and you're somebody who's entitled to look at them as a member of this body, you go look at them in the clerk's office. She pulls them from her book and she shows them to you and then she puts them back. They're not floating around. I think that's a very tight ship. I think that's great. Everybody told me that same story, including the mayor. The mayor has, at that point, had served over 6 years on this council as a councilman and mayor. Twice, he had asked to see executive session minutes. Not to get a copy, but to see them. He does not recall asking for 7 copies of one set of executive session minutes as recounted in the allegation and by your deputy clerk. Per recollection of the dates, plural, on which the request came, how it came, how it was responded to, was corroborated by other sources that she talked to at the time as to get guidance, the fact that she stalled until your clerk was back in town, have her help with dealing with it, was offered to be brought to a certain executive session for consideration of confidential documents. It was all very detailed. Your clerk's office keeps all the details. It's all very detailed. As far as I know, Ms. Pearson has no reason to not tell the truth about this. I think the mayor asked for 7 copies of executive session minutes of one session. I can think of no reason for that to have been done. I asked the mayor that even if he wanted a copy, why would he ask for 7? And his response was, well, there's 7 of us. And I said, but who else had asked you for these? I mean, you don't recall asking for them. You recall looking at 2 sets of minutes over the years. Do you ever recall Mayor asking for a copy of any set of minutes? No. Do you ever recall any member of this council ever asking for a copy of any executive session minutes? No. What about this occasion where you asked for 7? Did anybody ask you to get them a copy? Why wouldn't they go to the clerk and ask to see it in her office and like you normally would? No reason. I think the request was made. You do not have an open meetings law violation here because the minutes were not given. They were not distributed anywhere they weren't allowed to be distributed. If they've been given to the mayor, he's entitled to see them. He doesn't need 7 copies, I don't think, but he would, I mean, if you folks needed copies, I'm sure the clerk would give them directly to you and then take a pint of blood and only give it back to you when you return them. But that's not the way it all happened. I think the request came, I think it came 3 times. But it wasn't honored, and there was, this is like in basketball, no harm, no foul. I mean, the minutes were not shown anywhere. They shouldn't have been, so no violation occurred because of the diligence of the executive clerk. Another potential legal violation has to do with the personal information. I mentioned earlier in rather vague terms that the mayor mentioned to, again,